Welcome back. Now in this lecture we're going to take up the question of how are sales and lease contracts formed. What are the requirements to form a valid sales agreement? Now I'm not going to lie, there's going to be a lot of information here and it's somewhat densely packed, so you may need to go rewatch this lecture and pay special attention to your lecture notes. Now the UCC changed some of the rules of common law. We've kind of gotten that information so far. The UCC in many ways was an attempt to take the best part of common law and apply it to real life commercial transactions. When creating the UCC, the drafters looked to see how do transactions actually occur in the marketplace. What is actually being done regardless of what the common law rules may say. So the UCC in large part was an attempt to mimic what actually occurs in the marketplace. So UCC Article 2 is going to govern contracts for the sale of goods, as well as an Article 2A governs lease of goods, of course. Article 2 contains the elements of contract formation, and as I said, Article 2 changes some of the common law rules. These UCC changes are designed to facilitate the free flow of commerce. Remember, however, always remember this, the parties are always free to create different terms in their contract. The UCC is what we call a gap filler. If the contract is silent on an issue, the parties look to the UCC to fill in the gaps. So today we're going to look at the requirements of a valid contract. At the end of this lecture, you should be able to answer the following questions. How does the UCC change common law requirements for a valid offer? How does the UCC change common law requirements for a valid acceptance? And finally, what changes does the UCC make in other areas of contract formation? Let's start with one of the big changes to terms of an offer. The UCC permits open terms in an offer. And when we say open terms, we mean unspecified terms. So a contract under the UCC may be valid. It may be an enforceable agreement even if it has open terms. Now it must meet two conditions though in order to be enforceable. First of all, the parties must have intended to be bound by the agreement even with the open terms, and the agreement provides a reasonably certain basis for a remedy. We're going to look at remedies as the last aspect of contracts for the sale of goods. And we'll mention that a remedy, the thing that's going to fix a breach of a contract, is necessary in order to give the contract meaning. In order to find a remedy, we have to know what the terms of the agreement are. And therefore, we have to look back at that original agreement. If the open terms allow for a reasonably certain basis for a remedy, then the contract may well be enforceable. Now, the UCC gives us rules to deal with these open terms. These are going to provide rules that guide how courts and parties are going to interpret these open terms. And we'll look at each type of open term in turn. First of all, an open price term. As a general rule, if the parties have not agreed on a price, the court will determine a reasonable price at the time of the delivery. Now, an open price term is very different from common law. At common law, there has to be a price set forth in the agreement or it is not a contract. I lost a case involving a construction contract once because my client had not specifically named the price for his services. So if the parties have not agreed on a price in a common law contract, there is no contract. But in a UCC contract, the court can determine a reasonable price at the time of delivery. How do they do that? They look to see what's the market price for the good. What are others charging for a same or similar good? That's probably what the price should be. Now, if one of the parties is permitted to set the price in the agreement, that party must act in good faith. It's that good faith requirement again, meaning we can allow the buyer to set a price, we can allow the seller to set a price, but if they do so, they must act in good faith in setting that price. So if we agree to a contract with an open price term that says price to be set by seller at the time of fulfillment of the contract, the seller must act in good faith in setting that price, meaning it must be a reasonable price. If the parties have not agreed on the price due to the fault of one of the parties, the party not at fault has options. The party that is not at fault can either fix a reasonable price, or the party can treat the contract as canceled. And invariably the party will do what is in its economic best interest, to either set a reasonable price or simply cancel the contract, rescind the obligations that they have made and that the other party has made, and go recontract for those, for the purchase of goods or for the resale of goods. Open payment term. Again, an open payment term in a common law contract is almost always fatal to the contract. In a sales contract, if the parties do not specify otherwise, payment is due at the time and place that the buyer receives the goods. And the buyer can tender payment using any commercially acceptable means. Whatever type of payment is commonly used in the industry, the buyer can tender payment in that form. Now, the seller has a right to demand payment in cash, but if the seller does demand payment in cash, the buyer must be given a reasonable time to obtain it. Delivery. An open delivery term. Again, the contract usually sets out the delivery term. If the parties have any sophistication at all, they will set out in the contract when delivery is going to be made and where delivery is going to be made. But if they don't, the UCC will provide delivery terms if the contract is silent. And those delivery terms relate to place and time. First of all, if the parties do not specify the place, the buyer will take delivery at the seller's place of business. So no agreement as to place, the buyer is obligated to take delivery at the seller's place of business. Look for a problem like this on your exam. Now, if the parties do not specify the time, the seller must deliver within a reasonable period of time. And again, we determine reasonableness oftentimes by looking at things like what has been the performance in the past between these two parties, what is common in the industry or the trade. So reasonableness is a very gray area term, but it's one of those things that courts know when they see it. Quantity term. Again, failing to specify quantity at common law is fatal. Failing to specify how much is going to be required is fatal to a contract. The UCC recognizes only two exceptions to this common law requirement that quantity be specified in the agreement. And these are two specialized forms of contract. First, a requirements contract. A requirements contract is an agreement by which the buyer agrees to purchase and the seller agrees to sell all or up to a stated amount of what the buyer needs or requires. So we don't have to specify a quantity term. We can specify a provision that says the seller will sell as much of a product as a buyer requires. The second type of contract that is authorized by the UCC is an output contract. An output contract is an agreement by which the seller agrees to sell all or up to a stated amount of what the seller produces. So an output contract is obligation on the seller to sell everything that it produces, or up to a stated amount of what the seller produces. Now, in either of these types of contracts, of course, the UCC imposes a good faith requirement on requirements in output contracts. You cannot obligate yourself to take all the output of a seller and then refuse to do so on the grounds that you didn't make as much money as you thought you would. There's a good faith requirement. You can't ask for an agreement in which the buyer agrees to purchase all of its requirements and then not follow through on that promise. So there must be a good faith requirement in both of these requirements and output contracts. Open duration term. How long is the contract for? When will the contract terminate? Well, when a term is not specified, a duration term, it does not invalidate the contract. Instead, either party can terminate with reasonable notification. Now, in this case, reasonable notification would be how often are there goods delivered under the contract. So if goods are delivered, say, every 3 months, then a reasonable notification would be 3 months. Same if the goods are specified delivery on a monthly basis, reasonable notification of a termination of the agreement by either the buyer or the seller would probably be 1 month. So there are ways of figuring that stuff out. So that's the problem of open terms. Go back and look at all those because these are easy questions to ask but can sometimes be difficult to answer. Now, the UCC changes rules of revocation of an offer. An offer can be revoked and therefore no longer valid. Now, under the common law rule says that an offeror may revoke his offer at any time before acceptance. At any time before the buyer accepts the offer, the seller can terminate the offer, or vice versa. The offeror can revoke his offer at any time before acceptance. Furthermore, under common law, an offeree must pay consideration to keep the offer open for a stated period of time. So in the event the offeror says, I will sell you my construction service for $1,000, and you say, I need to think about it, can you give me 3 days? Ordinarily, the offeree must pay for that additional period of time. It's the law of consideration, because otherwise the offeree is going to get a bonus, something that more than what they would have otherwise been entitled to, and so therefore they must pay consideration for that. Now, the UCC changes this for merchants, a different rule for merchants. The UCC creates a special rule for what it calls firm offers. And a firm offer is an offer that's irrevocable even without the payment of consideration. Now, a firm offer must be written and signed. So in order to make a firm offer, I will sell you these goods for $1,000. I'll hold that offer open for 2 weeks. You can make that offer without the payment of consideration. However, it must be in writing and it must be signed. And furthermore, a firm offer is available only for a limited amount of time. The parties can set that time in their contract, or if no period is stated, then it's a reasonable period of time. But in any event, no more than 3 months. So no firm offer can be held open for longer than 3 months. The UCC also changes common law requirements for valid acceptance. How do you accept an offer? And most importantly, the UCC does this by doing away with the mirror image rule. The common law mirror image rule says that an acceptance must match the terms of the offer exactly. Otherwise, it is not an acceptance, but instead is a rejection and a counteroffer. The mirror image rule takes the position that a contract is formed if the offeree's response indicates a definite acceptance to the offer. Now, under the UCC, this is going to be changed. A contract is formed if the response indicates a definite acceptance of the offer, even if the acceptance includes additional or changed terms, even though the acceptance does not mirror the offer. Now, a purported acceptance can still be a counteroffer, and under the UCC, it may be more difficult to determine if a counteroffer was made or if it was an acceptance. So under the common law, it's a very clear rule that if there is if there's any sort of additional or changed terms, the offer is terminated, and the buyer can no longer accept the offer. The offeree can. So if I say I'm going to sell you my motorcycle for $1,000, and you say I will pay $1,000 as long as you throw in the helmet, under the common law, that would not be a valid contract because it did not mirror the offer. Under the UCC, it could be a closer call. The general way that courts do this is if the parties act as if they have a contract, the UCC will treat it as a contract. So no one is going to be forced into a contract with additional terms if they object to those terms. But if they begin to perform under the contract and only object afterwards that there actually is no contract, the UCC will treat it as if a valid contract had been formed, even though the acceptance did not match the offer. And what the UCC will do is they'll say the contract will consist of the terms on which the writings between the parties were agreed, plus any UCC gap filler terms. Communication of acceptance. A seller who chooses to accept must notify the buyer of the acceptance. Acceptance of an offer to buy or sell goods can be made in any reasonable manner and by any reasonable means. In fact, a party can accept, even without saying, yes, we accept your offer, by promising shipment of goods. A party may also accept by a prompt shipment of conforming goods, meaning goods that match the goods specified in the contract in every detail. So if I ship those out, then I am accepted the offer, regardless of whether I sent a separate acceptance, formal acceptance to the offeror. If a seller chooses to accept by shipping, it must notify the buyer of that acceptance. Now, if the seller ships non-conforming goods, that's going to constitute two things, both an acceptance and a breach by the seller. So a shipment of non-conforming goods constitutes both an acceptance and a breach by the seller. The treatment of additional terms in an acceptance can depend on whether the parties are merchants or non-merchants. So how should a contract address additional terms? When do they become part of the contract? when do they invalidate the contract, or when are they in the contract but not relevant because we're only going to enforce the terms that were agreed upon. All right. If one or both of the parties are non-merchants, the contract is formed according to the terms of the original offer. Even though there were additional terms made, those additional terms in the purported acceptance are disregarded if one or both of the parties are non-merchants, not doing business in the kind of the good that's being sold in this transaction. So we look, there is a contract, but it's a contract formed according to the terms of the original offer. If both parties are merchants, the additional terms automatically become part of the contract unless certain conditions apply. So if the parties are merchants, those additional terms become part of the contract unless certain conditions apply. And let's talk about what those are. The additional terms automatically become part of the contract unless the original offer expressly limited acceptance to the terms of the offer. The new or changed terms materially alter the contract. And material alteration is a tough concept. In general, material alteration has to do with those factors that are necessary to the performance of the contract. Factors like price and payment and delivery terms, quantity terms. If the new or changed terms materially alter those types of terms, they do not become part of the contract. And finally, if the offeror objects to the new or changed terms within a reasonable period of time, then the additional terms do not form part of the contract. The contract is formed according to the original terms. Finally, any purported acceptance that is conditional on the offeror's agreement to new or changed terms is definitely not an acceptance, but instead is a counteroffer. So if there is an offer made, an offer to sell goods at a certain price, and there is an attempted acceptance to pay a lower price, and a note that the acceptance is conditional on the offeror's agreement to the lower price, it's not an acceptance, but instead a counteroffer. Now, the UCC changes additional areas of contract law beyond simply offer and acceptance. And one of the ways that is most striking is the UCC changes the common law regarding modification of a contract. The parties have entered into a contract. The contract calls for delivery of a certain quantity of goods at a certain price at a certain time. And then what happens, one of the parties changes their mind. They need the goods delivered later. They need the goods at a lower amount. Well, under the common law, for an agreement to modify a contract, there would have to be additional consideration paid. The parties would have to pay in order to modify the contract. The UCC requires no consideration for an agreement that modifies a contract. So you and I are in a business relationship, and I indicate to you that I don't need these goods on December 1st, but I want to take them on December 15th. You as the seller can make that modification without demanding extra payment. It's a valid modification of the contract. That's a very common sense idea that is excluded from the common law because the common law has these very strict rules regarding consideration. Nevertheless, there are still a couple of requirements that are necessary for the modification to be effective. First of all, good faith. Again, good faith is required. To modify a contract, you must be acting in good faith and not simply trying to gain a competitive advantage over the other party to the contract. And there must be a writing. A writing is required in any modification of a contract. So if I call you on the phone and you agree to accept a later delivery date, that is not effective unless there is a writing involved. That is not an effective modification of a contract. The UCC includes an exception to the Statute of Frauds. Remember, the Statute of Frauds is a common law rule that says some contracts must be in writing. Most contracts do not, but some must be in writing. There is an exception to the Statute of Frauds regarding written contracts in the UCC. The UCC requires a writing for a contract for any sale of goods of $500 or more. Now in this case, $500 at the time of the execution of the UCC back in the 1940s was a lot of money. And the belief was that if a contract is for a lot of money, then the parties should write everything down. It's for the best to write it down. Nowadays, 60 years later, 70 years later, $500 is not nearly enough. But because states are so reluctant to change their sales law, this amount has never been amended by any state. There was a large movement back in 2003 in which the drafters of the UCC suggested $5,000 would more accurately reflect the intent of the original UCC of a big contract requiring a writing. Nevertheless, no state adopted that, and therefore we are still using this 1940s figure of $500. Now, if there's a writing, and in sales contracts of any appreciable size, there must be a writing. The writing has to meet certain requirements. It must indicate the party's intent to agree. There must be definite intent that is found within the context of the writing. It only has to be signed by one party. Both parties don't have to sign the agreement, but it must be signed by the party against whom enforcement is sought. Meaning, if you, the buyer, have entered into an agreement with a seller and you have signed your copy of the agreement, but the seller has not, you cannot enforce that agreement against the seller. Both the seller must have signed that in order to sue him to comply with the contract. And the same would go for the buyer as well. Now, in the case of a contract for sale, it must state the quantity of goods to be sold, unless it's a requirements contract or an outputs contract. And finally, in the case of a lease contract, it must reasonably describe the goods leased and the lease term. So the UCC has made changes to the Statute of Frauds. It requires a writing for any sale of goods over $500, and the writing must contain a definite intent to agree. It must be signed by the party against whom enforcement is sought. It must state the quantity of goods, and if it's a lease contract, it has to describe the goods and state the lease term. Now, between merchants, a written confirmation signed by one merchant may be sufficient. It may be a sufficient contract. And why is this? This is because when the drafters of the UCC were looking at how business is done, they found out that oftentimes what would happen is a party, a seller or a buyer, would make an offer. It would be accepted over informal means, orally perhaps, or in a conversation. And then the other party would write a letter of confirmation saying, This will confirm our agreement. Well, if it involves two merchants, a written confirmation signed by one merchant may be sufficient, may be a sufficient writing. The UCC includes certain other changes to the Statute of Frauds. An oral contract for specially manufactured goods may be enforceable. Specially manufactured goods are going to be goods that are not being bought off the shelf, that are not already produced, but instead were produced specifically for this agreement. And the belief is that we can enforce an oral contract for specially manufactured goods because the manufacturer would not have produced those goods without some assurance that there was an intent to be bound. An oral contract is enforceable in cases of judicial admission. What does this mean? This means that if a party gets onto the stand in a court of law and states there was an oral contract and this is what the amount was for, that is sufficient. That is sufficient to overcome the lack of a writing. And finally, an oral contract is enforceable in cases of partial performance. If a party has partially performed under an oral agreement, that may be enough to hold them to full performance of the contract. So those are some exceptions to the exception, really, the Statute of Frauds exception. The UCC also broadens what we call the parol evidence rule. If you remember back from your LSB 3213, the parol evidence rule states that if there is a writing, then nothing else can be added to that. If there is a writing, then the court are going to be bound by the terms of the writing. It's sometimes called the best evidence rule because the belief is that if there's a writing, that's the best evidence of what the parties actually intended. And we don't need to examine any other evidence because it's all there in the writing. Now, the UCC will broaden the parol evidence rule. It's not as draconian under the UCC. Now, written terms cannot usually be contradicted. However, interpretation may change the meaning of the contract. And when it comes to interpreting a contract, a court is not bound simply by the terms of the agreement, as they would in a common law agreement, but instead, a common law written agreement, but instead they can look at other features. So written terms can be explained or supplemented with certain other areas. The first is course of performance. And when we say course of performance, we look to see what has been the conduct of the parties to the agreement under this agreement. What have they done so far in conjunction with the execution of this agreement? Course of dealing refers to prior conduct between the parties to the contract that establishes a common basis for their understanding. If the contract calls for delivery on the 1st of the month, but it turns out that for the past year, the seller has made delivery on the 5th of the month and that's been accepted without complaint, well, that indicates that maybe the 5th of the month is the actual deadline for delivery. Usage of the trade, any term, practice, or method of dealing that is regularly observed in an industry, a vocation, or a trade, and would be reasonably expected to be observed in this transaction. Therefore, we can use that trade usage as evidence of what the parties were actually agreeing to. And finally, we can look at consistent additional terms. If the written contract is not the final and complete agreement of the parties, terms that do not contradict and would explain the writing, such as those in an email or a text or some other form of communication, the parties even if those terms are not included in the final agreement, they may be evidence of what the parties were planning to include in the agreement. So therefore, consistent additional terms. We can't contradict any terms in the contract, but if the terms are consistent with the contract and add to our understanding of the contract, then that is sufficient. Now, if there are conflicting contract terms, if the contract itself provides for conflicting terms, two terms in a contract, and this often happens because parties reuse forms, they reuse templates. Very few contracts are simply drafted from scratch. Instead, companies and lawyers will routinely use forms based on previous contracts. And when we cut and paste these various forms together to form a new agreement, sometimes conflicts are included in the contract itself. So if contract terms conflict, the UCC provides specific priority rules as to how we should prioritize our conflicting terms. First of all, express terms. This is the highest way. If the terms are express in one clause but are vague and unclear in the other clause, then the express terms will take priority. Express terms also take priority over course of performance. What have the parties done in regard to this particular contract? Course of dealing. How have the parties dealt in the past with this particular area? Course of dealing will take priority over trade usage, and trade usage will take priority over any consistent additional term. And finally, any term implied by law. What does this mean? This means like the UCC gap filler terms. Those have the lowest priority when contract terms conflict. The UCC also permits sales contracts to be voided on the grounds of unconscionability. Unconscionability is a tough concept. It really means grossly unfair. And a court may refuse to enforce a contract if the terms are grossly unfair to one of the parties. Now, unconscionability is hard to prove, in large part because courts are not meant to look at whether the contract was a good idea or a bad idea. Instead, they look for things like offer, acceptance, and consideration to know that the parties must have intended the contract. But sometimes, especially depending on the context, a court may refuse to enforce an agreement if it finds it to be unconscionable. And we see this often in the law. It happens oftentimes in these rent-to-own agreements, where a party will enter into a rent-to-own agreement for a new TV, say, and they will agree to pay $20 a week for the TV. What happens then? They have a term of the rental agreement, and in fact, after 5 years, the TV becomes theirs. But it turns out that the TV cost thousands of dollars more than it would have had they simply sold it to them at the time of the deal. And in that case, a court can refuse to enforce the contract in total. A court may also enforce the contract without the offending clause. If there is a late payment that is for a $200 rent and the late payment is $2,000 for payment after the first of the month, a court may enforce the contract, meaning you are still obligated to pay your rent, but you're not obligated to pay this unconscionable late fee. So what a court does is oftentimes limit the application of a clause to avoid an unconscionable result. And again, unconscionability is hard to recognize because it's such a gray area. On your test, when it comes up, make sure you know that we know that that the court has two options. It can refuse to enforce the contract at all, or it can enforce the contract but not the unconscionable provision. So in conclusion, what did we learn today? The UCC changes common law requirements for a valid offer. It changes common law requirements for a valid acceptance. And it changes additional elements of common law contract formation. Make sure you ask me any questions you have. Again, this is a very dense topic, and I know it covered a lot in one lecture. Covered very briefly in your book as well. So be sure to reach out if you have any questions about any of this. Thank you.